Welcome back. So today we had an action-packed day. Like I mentioned to you all in my last videos, Tuesday. Oh, look at her. There she is. The artist formerly known as Miss Boone Esquire. The chains have come back on. Isn't that how patriarchy always does it? But why is she smiling though? Who are you laughing at? Why are you looking at us? I don't like this. She's breaking the fourth wall and I need her to stay behind that wall. She has to have like a friend or someone in the audience that she's like surprised to see. This is like, that's so creepy. What? Is this is a game to her? Of course it is. She's winning everything that she's got, everything she's wanted. She's stalled all she. Wait, what? What's that face? I can't even do my introduction because what is going on here? We're going to try this again. Welcome back. This is Sarah Catherine Paulson. The comments finally told me what her maiden name was. Her maiden name is Paulson, apparently. And that's what I'm going to refer to her as. She has been dragging the Boone name through the dirt. Let that man and that child keep their name. This is Sarah Catherine Paulson. Sarah Paulson feels so fitting for this. And if you don't know who Sarah Paulson is, I'll give you a quick refresher.
Help! He's escaping! The killer is escaping! Help me!
Feels fitting, right? So yeah, that's going to be my channel thing. You know, if people get confused, they get confused. But Sarah Paulson is going to have to own up for her own decisions. She cannot hide behind Brian any longer. She, in that, that smile, I'm so over. I can't wait until this hearing wipes that smile right off her face. I'm gonna call it now. Again, I haven't gone through the whole thing. Yes, zoom in on her. Zoom in on her shady at. No, I'm gonna be calmer. I'm gonna be calmer today. I'll preface this. This is a commentary channel. There's a link below. Oh my gosh. She makes me not even want to finish this. This is so gross. Commentary channel, I'm going to talk a lot. You'll live or you won't. I'm sorry. The link in the description will be there if you don't want to hear me. But if you do want to hear me, let's get into it.
I'm James Owens, and I'm representing Sarah Boone.
Sir, good morning. Pleasure. Ms. Boone, good morning. Could you please state your, raise your right hand now. First, go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
Can I be petty? Let's be petty for a second. I hate how she always says 10-10-7-7. I get it. It's like, it's just easy that way, and she said it all her life. But I don't know. Does anyone else just feel like when she says that? Because she's never once just said October 10th, 1977. You know, sometimes you feel like you change it up or not, but it's always 10-10-7-7, 10-10-7-7. Mainly because I've seen so many of her videos, and she's, you know, been talking to the police almost all her life. She has said it so many times. Whatever. Petty moment over.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court.
She needs a pen to take all the notes that she doesn't need anymore because her lawyer is going to take care of it with those handcuffs that chafe her skin. Oh my goodness, that just feels great. I'm sorry, after doing that last video with viewing all the witness interviews, it really just has made me not very happy with Miss Paulson. Not at all. So I don't feel sorry for this. All the special privileges are gone. Yay, you didn't deserve them to begin with because you got your lawyers taken away for your bad behavior. So then to reward you for your bad behavior, you got special privileges. Although you were being punished by having court-appointed counsel forfeited for you. But as we see, someone stepped up. You still got what you want in the end. So you sit there in those cuffs, you smile, and you don't complain one bit.
On August 5, the court entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections has since passed. On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive or see such a notice in the court file. Mr. Castore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that viewing?
Correct.
Okay, all right.
So it sounds like Mr. Owens Esquire was not a part of that viewing, which means he's probably going to want to see the stuff too, the physical evidence. I mean, he would need to, but they're not doing this again, so he's going to have to schedule it on his own time to see it with the state. And if he does that, he better not ask for more time. It still should be from this date of September 3rd, because it said that you have 2 weeks after viewing the physical evidence to lodge your objections. It should be 2 weeks after today, instead of 2 weeks after whenever he finally views it, even though I know he's going to probably ask for, well, once I finally can set up a chance to look at it, then can we lodge our objections? And it's just going to be da-da-da-da-da. But she should be happy. She got to see the physical evidence. It doesn't matter now, right? Like, the lawyer still needs to see it himself. He's not going to say, hey, Sarah, can you describe to me what you saw, and then just go off of her word. He's going to want to ask to see it himself. But, yeah.
Thank you very much. Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense. That was filed on August 14th. The next day, August 15th, JSCS filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that the JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times at the Orange County Jail.
Then there you go. In your motion for continuance, you said you needed extra time because she needed to develop a trusting relationship with whoever to get whatever diagnosis for battered spouse syndrome. And you have someone. She's met with her already. If she doesn't trust her, she's out of luck, okay? She didn't have time not to trust anyone. That's why she gonna sit her happy ass down and not fight with. She better not fight with Mr. Owens Esquire, or else you'll be on your own again. And I'm sure that smile will definitely be wiped off that face if that happened. But he just completely abandons her motions that were not well done. Now that I think about it, I guess the YouTube lawyer is the one who helped her out with the neuropsychiatrist motion, which at least was written better. It was written the best thing that she's ever done. But I don't think she understands the difference between a psychiatrist and a psychologist. A psychologist is more, the way I describe it is, psychology is like therapy, psychiatrist is like medication. Psychology is more the examination of the broader umbrella involving behavior, yada, yada, yada. Psychiatrists are medical doctors. So she was looking for a neuropsychiatrist to create these connections between whatever brain condition she might have and connect that to decision making based off of past traumas or whatever. But if you're going the neuropsychiatrist route, that means you want tests done, brainwave scans, all of these things to try to medically prove that there is something wrong with you that caused you not to be able to be in control of your decision making, what have you, yada yada. While a forensic psychologist, which is the direction Mr. Owens is going, is actually going to be able to, sit with you and do psychological assessments and not medical assessments, and then be able to make those claims based off of what they observe and what they diagnose her with, yada yada. So that is the right pivot. It's just really funny I never put it together. A neuropsychiatrist. That's why the JAC was like, you have to prove to me why you need it. If you're trying to get a neuropsychiatrist, you have to be like, I have X condition that requires X test follow-ups. And then you would have to get all that time to get the test set up, and then the results, and then the analysis of the results, and then...
She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times. Haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer.
I bet you haven't. I wouldn't answer the phone either. Because what? That's like your abusive ex's new boyfriend calling you saying, hey, how do I deal with this? Do not call me about this person. You better get in your sinking ship of a submarine and navigate these choppy waters yourself, because boom, 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 I washed my hands of it when I gave you those nasty cardboard boxes that she begged for so long. As soon as that Lord of the Rings ring, your precious, my precious, got delivered to you, done. No more control over you. The Eye of Sauron. I don't know what I'm saying anything. I don't even know if that's the right thing. You get the metaphor. It's your own problem now.
But we don't need this neuropsychologist that Ms. Boone had requested. But
Oh, so she did ask for a neuropsychologist. My bad. Either way, a neuropsychologist versus a just regular psychologist is just very tailored lane. So she still needs to prove why she needs a forensics neuropsychologist and not just a forensics psychologist, which is the better path to go, which is why he just ignored it. Good on you.
we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for battered spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion.
So this is a forensics expert that they retained in the past through one of her 8 lawyers. And then I guess the next one abandoned it for a while, and so that doctor got off the case, and now they want to rehire her. I think the first lawyer, which was the second attorney, but the first official attorney, Mr. Padilla, found this expert and was going to use them back when they were weeks away from trial years and years ago. And now he's just circling back because he's like, well, that guy was ready for trial. I guess we should just probably use his playbook. But Sarah didn't want to go that playbook. The whole reason was because they had an adversarial relationship, because she said she did not want to go the route he wanted to go. But maybe this battered spouse route is the way. No, still, I don't think this is the route she wants to go, because that means she has to admit it was intentional, which it was, but she's never wanted to admit that. I think now that she's been her own lawyer and realizes I can't do any of this on my own, and that it's better to have any kind of defense rather than me trying to make it perfect. So yes, now I'm going to go along with it was battered spouse. It was intentional because he beat me this, he beat me that. And he says, yeah, after talking with her, I think that she meets the criteria for battered spouse. Yeah, so does literally everyone who's ever talked to her. They all think that she is a battered spouse. And then they find out what she's done. And they hear her, and they see her actions, and they see how violent and provocative and physically aggressive and mean and loud, and then they see a clearer picture. So I'm sure, sir, I'm sure from you talking with her the 4 times you've met her, you think she's the perfect battered spouse. But as you learn more and more in your discovery, I think your tune will change.
In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkland, who is from my area, Pensacola, is who I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berkland. I filed these, Judge, yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motion to dismiss.
Can I approach them in?
Yes. State, have you seen them?
I just saw them briefly this morning prior to
Morning, sir.
the hearing.
Thank you. The only thing I saw in the court file, counsel, when I was prepping last night was the motion for statement of particulars. They call it September 2. I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
So I have a motion for statement of particulars filed at 8:10 yesterday, but I do not have the motion for additional discovery filed 8:34.
I don't know why the court was not able to post that, because they were filed one right after the other.
One's in the court file, and the other's three aren't. They were all filed yesterday, 9/2.
No, certain things auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that.
Okay, it's the next day. Cool, it's the next day, which is good because we're going to take a detour. Since this video is coming out later than I want anyway, I decided to go ahead and put in the motions that they're all talking about. So let's just run down these motions, get a general idea, and then come back here. If you don't want to see this part, timestamps will be in the description. These motions include the motion for additional discovery, a motion for particulars, a motion to appoint the forensic psychologist, a motion to appoint crime scene constructionist, death investigator, and I think that's it for now. Motion for additional discovery. Comes now the defendant by and through the undersigned attorney under Rule Florida Rules of Criminal Procedure and requests this court to enter order requiring the state of Florida to furnish additional discovery and as grounds alleges 1. Under additional discovery on a showing of materiality, the court may require such other discovery to the parties as justice may require. 2. Specifically, the defense is requesting the Office of the State Attorney to provide the written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures. In particular, the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office. Wherefore, the defendant would respectfully request the court consider this request and grant the defense for statement of particulars. James Owens. So basically they want the interrogation thrown out. So they want the policies and procedures to see if they can see where Chelsea and Scott went wrong. And, there were some mistakes, but not enough to get it thrown out. Not at all. The biggest mistake they made was swearing her at the end, because if she was any kind of smart, she would have just said, "No, I lied. All of this is a lie." Sorry. Motion for statement of particulars. Comes now the defendant by and through the undersigned attorney, rule under of the Florida Rules of Criminal Procedure, and requests this court to enter an order requiring the state of Florida to furnish the defendant with a state of particulars concerning the alleged offenses, including the following. 1. The defendant Sarah Boone is charged by way of an information with a single count of second-degree murder. 2. The pertinent part of the information states charges that Sarah Boone on or about 23rd day of February 2020 in said county and state did in violation of Florida statute by an act eminently dangerous to another and evincing a depraved mind regardless of human life, did kill Jorge Torres. 3. Under the Florida Standard Jury Instructions for Criminal Cases 7.4 Murder Second Degree Section to prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1. Victim is dead. Check. 2. The death was caused by the criminal act of defendant, zipping someone in a suitcase, the said suitcase where he was found dead. Check. 3. There was an unlawful killing of victim by an act eminently dangerous to another or demonstrating a depraved mind without regard for human life. Zipping someone up in a suitcase who you then know is yelling for help and you're responding to them, saying no. Check. Definitions. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1. A person of ordinary judgment who would know is reasonably certain to kill or do serious bodily injury to another, and 2. Is done from ill will, hatred, spite, or an evil intent, and 3. Is of such a nature that the act itself indicates an indifference to human life. You literally ignored him and told him to shh. How more indifferent can you get? 3 more checks. Check, check, check. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. There it is, right then and there. You did do it. The state does not have to prove you intended to cause the death. They just have to prove that you did it with malicious intent, basically. 4. Under Florida rules of criminal procedure, a defendant has the right to know of the charges against them with specificity. 5. Upon request, the state must provide specificity and clarification on the details of the alleged offenses in order to minimize surprise at trial and ensure that the defendant's rights are protected. 6. The rules require the information on which the defendant is to be tried shall be a plain, concise, and definite written statement of the essential facts constituting the offense charged. 7. The information fails to inform the defendant of the particulars of the offense sufficiently to enable the defendant to prepare a defense. Wherefore, the defense would respectfully request the court consider this request and grant the defense motion for statement of particulars. James Owens.
There's nothing wrong with that. They just want more specificity, which I mean, I feel like they already have. But there's 2 ways that you can get charged. And we went through little definitions a few videos back, discussing the difference between an arrest, a charge, and a conviction. Arrest being detained for a suspicion of a crime, a charge being formally accused of a crime, and a conviction being found guilty or not guilty. So in terms of charge, you can get charged by 2 ways. One is by indictment, which is grand jury, which we talked about in another video about those 15 to 20 people who they hear the evidence from one very tailored, overly weighted side, and then they see, is there enough here to actually have a trial? They're not there to judge guilty, not guilty. They just say, yeah, you can do stuff with it. 90% of the time they say yes. And the other way is by way of information. And that is when the prosecutor themselves makes the accusation. It's when they think, oh, we already have all the evidence we need. We don't need to convince anyone. I am confident enough to charge them myself. Maybe. That's my thought when doing that. Either way, it's when the prosecutor themselves makes the accusation. So they are saying that Mr. Petrich, Mr. Cacciatore. I almost said Mr. Petrocelli. And you know what? Yeah, if you don't know who that is, I'm going to do the side tangent.
Well, hello there, Mr. Petrocelli.
Thanks for coming.
Anything for my baby's favorite teacher.
She really carried that channel on her back during the 2000s. Anyway, Mr. Cacciatore did not provide them with specific enough information, so they say, so they want them to just give them a more detailed account. Don't worry, Mr. Cacciatore, I got you. Miss Sarah Paulson, let me break this down for you. You are charged with a second-degree murder because you zipped your boyfriend in a suitcase, filmed basically a snuff film while you laughed at him, and then you left him there for 12 hours. I think that's pretty specific enough. Motion to appoint forensic psychologist. Comes now the defendant by and through the undersigned attorney and moves this honorable court for the appointment of a due process provider to aid in the preparation of the defense in the above styled causes, and as grounds would show. 1. The defendant is charged with second-degree murder and has previously been found indigent. 2. The undersigned attorney is privately retained and requests the assistance of a forensic psychologist to aid in the defense in this manner. 3. The defendant is financially unable to hire a due process provider, forensic psychologist, to aid in the preparation of the defense and therefore requires the assistance of the court to ensure the protection of her right to due process and effective assistance of counsel. 4. The defense requests the court appoint Dr. Julie Harper, a forensic psychologist, for the defendant. 5. Dr. Harper is requesting and has been paid in other court-appointed cases at a rate of $200 per hour to perform her duties, including time spent traveling. 6. The undersigned requests Dr. Julie Harper be appointed at a rate of $200 per hour for the work and time traveled with an initial cap of $7,500, exclusive of necessary costs allowed by statute. How many times does this JAC have to tell you the cap is $3,000? Why you keep throwing up numbers you know they will deny? It's just the initial cap. I'm pretty sure you could argue if you need more funds afterwards, but you want to get the people hired first and then be like, well, look how much stuff they did, pay them their stuff. Not, here's what they're expecting, give us this, even though we know you're going to reject it because you've rejected everything else, even Bankowitz and the other lawyers, when they have asked for things high and above the $3,000 cap. Whatever. Wherefore, the defense respectfully requests this court to appoint Dr. Julie Harper to assist the defense as a forensic psychologist, certificate of, James Owens. Motion to appoint crime scene reconstructionist and death investigator. Comes now the defendant by and through the undersigned attorney and moves this honorable court for the appointment of a due process provider to aid in the preparation of the defense in the above styled cause and as grounds would show. 1. The defendant is charged with second-degree murder and has previously been found indigent. 2. The undersigned attorney is privately retained and requests the assistance of a crime scene reconstructionist death investigator to assist in the defense. 3. The defendant is financially unavailable to hire a due process provider, crime scene reconstructionist death investigator, to aid in the preparation of the defense, and therefore requires the assistance of the court to ensure the protection of her right to due process and effective assistance of counsel. 4. The defense requests the court to appoint Dr. Michael Birkland, a crime scene reconstructionist death investigator, for the defendant. 5. Dr. Michael Birkland is requesting and has been paid in other court-appointed cases a rate of $200 per hour to perform his duties, including time spent traveling. 6.
The undersigned requests Dr. Michael Birkeland be appointed at a rate of $200 per hour for work and time traveled with an initial cap of $6,000, exclusive of necessary costs allowed by statute. Wherefore, the defense respectfully requests this court appoint Dr. Michael Birkeland to assist the defense as a crime scene reconstructionist, death investigator, certificate, James Owens. Again, $6,000 cap. How many times do they have to tell you it is a $3,000 cap? Like, he should have read the rejection letters beforehand. I mean, I get it, put it up there, but again, that was their whole issue, is they could not find anyone who would do this for the rate that JAC was willing to pay. So good luck with that. But those are all the motions that everyone's talking about, and now we'll get back to the hearing.
As the court previously identified, JACS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They are not here. Your motions for these various experts report that they were sent to all persons on the service list through the e-portal. But I don't know how I can address these this morning without having JACS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed.
Just also to note, this is the third time that they have not submitted these requests to JAC correctly. The first time she was handwriting asking for the world, the JAC said, okay, you need to submit this to us first so we can deny it. Here's this pro se packet to help you out. Then the second time she sent it, she gave an extra copy to the judge saying, okay, there's 2 provided, so that counts, right? And he's like, no, because the JAC still hasn't seen it, so we can't do anything with it now. JAC has to respond, then we come back here and do this. And this is the coming back here, and he's submitting 2 more motions, again, not to the JAC first, who has to deny it first before Cranick can make a ruling on it. That makes no sense. And even if the JAC was there, they put in their motion they didn't want to be there. But if Cranick had asked them to show up and for them to be there, then they still wouldn't have been able to make a decision on it right then and there. They would have had to prolong it even more. Whatever. Just do it right once. I know the JAC is annoyed.
Be advised, this is a trial week for the court, as is next week. But I will do my best to endeavor to try to get these heard as soon as possible.
Judge, and I filed my notice of appearance on Friday,
yes,
and I've spoken with Dr. Birkeland 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Birkeland. I believe he has the autopsy. We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So,
yeah, I wonder why you can't find them. I wonder why you can't find different parts of the discovery. Maybe it's because Miss Paulson has had the boxes right next to her bed for, weeks now? Maybe it's because she didn't have paper clips or staples, so everything is just jumbled up. You know it was a mess, especially when she had to move it over to the property bag and the envelopes. It's there. It's there. You also had it / have it in the digital form that Mr. Billy Lane did himself. If you don't have these things that you're saying Mr. Billy Lane is a fraud and did not do his job because he was tasked with photocopying everything in the infamous boxes and then providing it on the USB. He did that. And then they provided the actual boxes themselves. For you to make that claim, you're saying that none of the prior 8 attorneys had those photos either, because everything is in those boxes. Unless you're saying that they hoarded them themselves. Just wild. You have it. It's just not organized, and you're running out of time.
I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and providing them to counsel?
We've provided all of those things previously, obviously, to the defendant, which has been greatly discussed already.
Exactly. And that's how it goes every single hearing. She is brought up so many times. And she said in the letters, even back when she didn't even know what was in the boxes, that these mythic missing material things are in the discovery that are not there, that were previously there, I guess, apparently, because she saw them but didn't see them, but knows that they were supposed to be there. She always says that something is missing. Can't tell you what it is. That is not their fault that you are not tech literate. I'm sorry about that. You got to keep up pretty quickly, but that does not mean you do not have it. She says she doesn't have evidence like this. That's what she kept saying with the phone. I don't have my phone. I need my contacts. You have the mirror imaging both digitally and in hard copies and recordings that are in there, whatever. Just mind-blowing. How many times are you going to tell us you don't have anything where everyone else has to say it's there? Do you need them to hold your hand as you open the file together and see, look, there it is. That's the icon that we told you to click on, that you needed to click on, and now that you did, you can see it, right?
When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent notice to as well that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB, and we can go ahead and burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to get that information to him?
If he wants to come back to my office, we can do it this morning / this afternoon.
Is your office in the building?
Yes, it's in the courthouse.
Right there. Come out the front door, make a left.
Okay. I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay.
Then there you go. Miss Paulson, you got another win. They are going to give you this discovery for the third time, personally. I mean, I guess if you want to say how many times has the prosecution had to check to make sure you had the discovery, this would be the 11th time. After 8 attorneys, 9, 10 with the hard and the digital discovery, and now we're at 11 with another jump drive. They'll look at the state's computer and get it in front of them face to face and still say something's missing or that the file was corrupted.
Appreciate you both. With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., state you the opportunity to review this.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both this motion and also the motion to the statement of particulars formally in writing, given the lack of time we've had to prepare to make a quick formal response.
Sure. And how much time, Counselor, would you like in order to file a...
I still want to know what is so funny to her. If I'm being the nicest, there must be someone or something that she's familiar with in the gallery that is making her react that way. If I'm feeling how I feel, it's like she's looking at the news channels and I don't know, is she smiling, gloating, happy, I mean, I guess she is happy that she doesn't have to answer these questions because she was floundering, but I'm like, this has to be some internal self-satisfaction. This, look, I got what I wanted again, I'm saved again, and it's all because of what I did. And she's right. She put out that Circus Help Wanted ad. He read the Circus Help Wanted ad, hopped in his little clown car, came on down here and decided to put on a show. And that's just, a metaphor, whatever, just a little joke. But he is actually not doing a bad job. He's pretty confident about what he wants, and it seems like he has a clear direction. So I'm definitely not mad about his performance, especially compared to Miss Paulson's performance. But that smile still just isn't cute.
response to the motion for statement of particulars and the motion for additional discovery.
I would ask for at least a week.
Any objection?
No objection.
Okay, all right. The state shall file a response to both the motion for statement of particulars and the motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th. And if hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense, the court's going to deny that as moot based on Mr. Owens' representation. With regard to the motion to appoint crime scene reconstructionist and death investigator and motion to appoint forensic psychologist, State, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Barrios, I'll ask the clerk to see if we can push these through the portal today so that Ms. Barrios can reach out to JICS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add one other forensic psychologist.
Of course you do. Of course you do. Why stop there? Go ahead and ask for an expert in suitcase construction next. No, I'm joking. He's doing exactly what he's supposed to do. But man, he is coming out swinging. I'm just wondering, there's just so much to coordinate with all of these witnesses. Why is he so invested in doing this for free? This is a lot of resources. Like, I get wanting to represent her, but he is trying to put on a full-blown defense in 30 days, which is good for him. I just don't get what he gets out of this. So,
You know, I want to make sure that there's not an issue about my client Sarah Boone and I manufacturing a defense.
that's exactly what you're doing. You are absolutely manufacturing a defense. No, it's fine. I get it. He's saying that he wants these expert opinions so that he has a basis to back the defense that they're going to go for. He's going to go for battered spouse defense, but he needs experts to say, hi, she has battered spouse syndrome. What, I don't know what they need to say, so that he can actually say, hey, we have factual basis. And now from professional experts, doctors, whoever, now we would like to officially present the battered spouse defense. However, that is a lot of people, and you have until what? In the motion continuance, it was like September 8th to declare it. So you were trying to coordinate all of these people to look and evaluate her and come back with their own opinions that you need by the 8th. Okay.
And there's a second doctor, Dr. Michael Brannon. Dr. Michael Brannon?
B-R-A-N-N-E-N?
He spells it B-R-A-N-N-O-N. He was the forensic psychologist in the Marsha Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband. Shot him 9 times. He was laying on the couch and was acquitted of first-degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial. But Dr. Brannon testified that a battered woman's experiences affect her perception of imminent danger.
Which is true, but that does not apply here. Because with that case, I don't know the particulars, but it sounds like he was on the couch and probably sleeping or what have you, and then she killed him. However, he could have awoken. He could have come after her. He could have attacked her. So she could have, depending on the abuse that she suffered in that relationship, could have felt in constant fear and that at any moment he could attack. George was confined in a suitcase. There was no fear of imminent danger whatsoever, as evidenced by the fact that she sat on the couch instead of the husband. And if you're going to make the parallels, she was on the couch, he was in front of her, confined there and laughing. She was laughing. So unless, I don't know, someone who's terrified pulls out a camera and laughs at their confined abuser as they watch them slowly expire, that does not mean that you were in imminent fear.
Now, if she wants to play the smartest argument, and I'm going to go off on a tangent because it's come to my mind and I'm just going to let it freeform. The smartest narrative she has is, unfortunately, through Brian. Because if she wants to do this battered spouse defense thing of he got in the suitcase and I was too afraid to let him out, I did not want to let him out alone while I was there because I was afraid he was going to attack me. That's why I made that 11:46 phone call, the phone call that Brian ended up deleting that we learned about in the witness interview. And she could have just been like, I called him to come over because I needed help, and then I passed out because I was drunk. But I was waiting for him to come over, and I just assumed that he would come over, and then I would feel more comfortable letting him out. That's probably her best narrative that she could string together. I think it's horrible because it drags Brian into things when he precisely avoided walking into that house because he didn't want to be involved at all. And if he had walked onto that carpet, she probably could have spun that story even more so. So she could say that narrative. And she could say, I was waiting on Brian to show up 100%. I thought this, I thought that, And it's not Brian's fault for any of that. But that could put in her mind state that she did not intend to kill him. She was just intoxicated, decision making. She feared for her life letting him out, yada, 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 yada. But I mean, you can absolutely destroy that story as well. If you were fearful of that, why were you filming for such a long time? And between intervals before calling Brian. And then after, when you woke up the next morning, why didn't you call Brian immediately? You told us you didn't remember, you didn't know, you thought that he would get out on his own. But to make that make sense, to make it make sense of you intentionally killing him, and then because you were afraid for your life, you would have had to know when you woke up that Brian wasn't there, that Brian never showed up. So why didn't you call Brian to say, oh, da-da-da-da? Which I guess that she can also use that narrative of saying, well, why did I call the police first? Because I called Brian last night thinking he was going to come over. It was just instinctual. I needed him to come over because I was paralyzed, fear, yada, yada, yada. He's been my Superman. We've been together for so long. I was terrified, battered spouse, yada, yada, yada. None of it will hold up because all he has to do is get on that stand and say, yeah, she abused me physically, emotionally, consistently. Sorry, side tangent over.
That's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger.
Not this shady ass camera again. They said, let me zoom in real quick. Does that look like the face of imminent danger to you? This camera guy needs a raise stat.
In addition, Dr. Brand said victims of repeat violence may fear death in situations others would not. And
he said, and what about it? And I just know that she expected I don't know what reaction she expected, but she didn't get the reaction she wanted. Oh, so she's going to curl them lips back like she is upset and pressed, like she is hiding back what she really wants to say. But yeah, we hear what you're saying. We all know it doesn't apply to her. So, and what about it? Even though I know he's saying and being like, and what was the result?
I've tried to reach out to Mr. Brandon this weekend unsuccessfully. And my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours.
Not he claims on his website. You do not have time, sir. You do not have time to be knocking at people's doors with a rusty cup begging for some spare change. You do not have that time. You need to call people who will pick up the phone and give you what you need, or you need to pivot.
That's the only other witness I'm going to need an appointment for a forensic psychologist. With two forensic psychologists, Dr. Julie Harper, Dr. Michael Brandon, and then the crime scene reconstructionist, Dr. Michael Burton.
All in all, that's not that bad. I know I've poked fun at it, but that's enough to make like a concise defense, I think. However, you're asking for the court to make it their problem to figure out how you can get them here. You got to figure out how to get their butts on that stand.
And then in addition, I would like Billy Lane, who's seated in the audience, he is the investigator on the case, because of the claims that we're making that she's a battered woman.
That shady cameraman is at it again. But I am glad Mr. Billy Lane is getting some love, but dang, this this man is working overtime, giving you production value. Good for you.
We need evidence to corroborate that, so there's a lot of history between her and Mr. Torres involving the apartment complex, which is in Winter Park. That was 4 years ago. The ownership of that apartment complex has changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these two, as well as we're trying to get together the 911 calls that Sarah made and others have made about the disturbances between that couple. So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrest of Mr. Torres, as well as the officers involved in their body cams to see if there's any evidence on the body cams that would show injuries to Miss Boone. So we've got a lot of work to do.
You sure do. This sounds like a whole lot of your problem. What does that got to do with me? You're just telling me all the things you have to get done because you decided to walk on. No one told you to be here. I'm sorry. Like, you told me that you were going to appear here, and now you're making you my problem? No. There are you problems, and then there are me problems. This is very much a you problem. So he just keeps asking for more time, and I get it. You have to, and it's going to work out better for you when you're making appellate arguments that you did try to just put all of this on the record. But I feel like some part of him thinks he deserves one or should get one. And it's like, no. What's the whole point of any of this then? If a lawyer can show up a week before trial starts and then says, okay, let's put the whole thing back. Because that's what you're asking. It's just on a different scale, but it's the exact same argument. I just decided to show up. Even though you said we're not going to give a continuance, let me tell you why I still need a continuance. He used the word extraordinarily good cause for a reason. Every word in law means something. You don't use extraordinarily for a simple manner of you need expert witnesses. That is a very basic request. So I need something a little more extra and a lot less ordinary. Denied.
I believe it's necessary for us to prove a viable defense of battered spouse syndrome, that we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other. Of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs.
You better not. What does that even mean? That's like calling up someone and say, hey, I'm going to be over for dinner in like a half hour. And then you show up and say, okay, don't worry. I know I was late, but I'm not going to ask for gas money. What? There would be no cost for you to claim. Ooh. I do have to say, I still do like Mr. Owens. He's doing a great job. It's just some of this.
Just for these words.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JCS may change their position with regard to those costs since they've already said yes, but file it and we'll try to tee it up for hearing as well to see if they have any position, or it could just be, the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right.
That is a very polite way of saying no. Now get the F out of my face. Billy Lane over there in the corner has your little piggy bank. Make do with what you got.
Which, by the way, because yeah, the JAC on Zoom when Zordon upped the ante and said, okay, you can move it from 5,000 to 10,000 because he thought that Billy Lane had already taken a lot of money just to create the digital discovery. You know, the digital discovery that Sarah Paulson has done nothing but complain about. Yeah, so a lot of her $10,000 was wasted just getting that. You know, the digital discovery that definitely has the autopsy photos on it. Yeah, just throw that away. Which means there's not a lot of money left in there. So, good luck with that.
That takes us now then to your motion for continuance file that was filed on August 30th. Court's had the opportunity to review that motion. Any other argument or statements with regard to that motion? Mr. Owens.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it, but it is critical to my theory, our theory of defense, battered spouse syndrome. And as you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th.
And there's your first nail in the coffin, so you still have time. I don't care how improbable or difficult it is, you still have time to do this. This argument would be one thing if it was in the past. Although the objections to the digital evidence happened in the past, that is more of an argument to say, can I do something now because that happened before I was here? But you are here. You chose the date in which you wanted to show up. You have already admitted you had met with her 4 times. Any of those 4 times prior, you could have appeared on that same day. You know, so what is it? My mom always said this one statement, like, a lack of preparedness on your part does not constitute an emergency on my part. And it's so true, because just because you're not ready doesn't mean it's my fault you're not ready. And just because you decided to show up late doesn't mean it's my fault you decided to show up late. I hear all the hurdles you have to deal with, and yeah, that's not really great. And normally, in different circumstances, if I had not specifically put in there that the retention of counsel by the defendant would not be extraordinarily good cause to alter anything, more or less, or to alter the start of trial, then you should understand that walking in here, you are walking in within this set period of time. Unless you can move mountains, heaven, and the earth to show a really good cause, other than some medical accident or something that might happen. Ooh, not the train. The train had a lot to say about that one. That's all I want to say. But yeah, you knew what you were walking into. Now, best of luck.
But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement. That was just between the two.
So you took on this case without looking into it? Yikes. So what are you going to do when you look into it and find out that she was the primary aggressor in most of these instances? Because if you go down this prior DV route, her prior 3rd-degree felony for strangulation gets to come in. So it's not going to look good for you to say, look how many times he abused her in the past. And the prosecution says, look how many times she nearly tried to kill him. Oh, also what we learned in the witness interviews. Let's take a little tangent on that, because the reason why I'm so kind of vitriolic is just because of the things that we learned from those witnesses.
Some things that we learned. We learned that, first of all, we did learn that George did start some violence sometimes. That's what some people said. That's what he admitted, that he did initiate it sometimes, but that Sarah initiated the majority. And that was confirmed by everyone else's accounts as well. She attacked and pushed his father. She got him kicked off the lease. They shared a phone, which then in the interrogation, she says he doesn't have access to. Like, he doesn't have the password or the facial ID to. She called the police on him 16 times in 1 year. She controlled the car. She kicked him out to the point where he had to go sleep in a tent on someone's random backyard. Oh, and she hit him with a car. Yeah. So if you really want to dig up this stuff, and you want to dig up and say how abusive George was, it's not going to look good on her. Because then you just go back to their last relationships. Allegedly, George never had any domestic issues before being with Sarah. And that his ex-wife, who he has 3 kids with, I have no confirmation of this, but just what I've seen in the comments and what other people on other channels have said, is that they had a fine relationship overall. You know, standard couple things, but it was not violent or abusive in that manner. I don't know for sure. If other information comes to me, then I will readjust my opinion. But if that is true, looking at Sarah's past relationship was also abusive, solely from her half. Now, I'm sure he probably verbally fought back when he could, but it didn't seem like he did anything physical because the marks would have shown up and no one said that they saw any marks on her. However, they did say they saw marks on him. Scratch marks. He admitted to having scratch marks all over him regularly, that she would punch him regularly. So if you want to go down this battered spouse, you can't really be a battered spouse when you are the one battering your spouse.
So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a battered spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day, yesterday, as well as the other 4 times that I've met with her.
Well, if you have all that, that's all it takes, folks. If you spend 3.5 hours and 4 little visits, you too can qualify as a battered spouse. No. And I get it, he's fine doing what he has to do, but she's like holding back a little half smile of confirmation of like, So she's agreeing with this new course of action, which I get it. People have to go with the defense that they think can help them the best. But there's something truly heinous in my mind about defenses that blame the victim, especially when it's such an impassioned, heartless, literally depraved heart feeling murder. That's what you're being charged for. You're being charged for 2nd-degree depraved heart murder. Showing remorse, showing your mental state, showing your actual feelings at the time of the crime is going to be the mitigating factors of what you get sentenced and how you get sentenced. And you choosing this defense path will come into play. It's similar in my mind to Letitia Stout going to the plead by insanity defense. I may have said it earlier, but she's saying, yes, I did do it, but I didn't do it because I wasn't in my right mind. Now she is saying, yes, I did do it. I did intentionally mean to kill him. But it's okay because I was the one actually afraid. I was the one scared for my life, which is why I filmed it laughing. That those laughs are actually me crying. Those like taunts are actually me begging him not to. See, to make these things make sense, you have to completely invert them. And again, I get it. She's doing it because she has to. I still don't have to like it.
I haven't spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I don't believe you were involved at that time. I may have been.
Not me.
Okay.
My predecessor was.
But I think it was always ready to go. And for whatever reason, he withdrew at the last moment.
For whatever reason, the reason is sitting right to your right, directly to your right. That is the reason. In the motion to withdraws, he says adversarial relationship and ethical considerations. That is her to a T. She is the reason for that. And you're going to learn that too. You're going to learn that soon enough. But for now, you keep doing you.
Here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim. And I would respectfully ask, I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles sometime at the end of the year or first of next year.
See, no, even there, you pushed and pushed the times. I'm just asking for 1 trial cycle, maybe 2, end of the year, maybe the first of the year, maybe 2 or 3 months, maybe 4 or 5, 6 or months. And I get it. You're asking for a little one, quote unquote, but this is where we're at of you have abused every single extension she has been provided ever. None of it has been progressive, according to Miss Boone. She has had 4.5 years and still cannot put on the same one failing defense. It sounds like all of them had tried in some form or another to make this defense work because nothing else works, right? There's no other defense in this case. This isn't even a defense for this case, but it's one that she can kind of grasp onto and she can claim herself as the victim and that she's the hero of her own story. I mean, she's always the hero of her own story and the damsel in distress and the villain. The whole story is always about her. But yeah, you're not giving any set specific amount of time. And you're saying it'd be prejudicial. No, you came on here today. It is not prejudicial for you to show up late and then get mad that everything has been preset out. You saw the order. It said no continuance would be granted. If that wasn't in the order and she was just forced to go, or like she just had court-appointed counsel taken away from her, then you could make all these arguments. You could call it prejudicial. You could call all these things. I know you're pulling it out your ass, just trying to make something stick to the wall, but still, she thinks she deserves it, and that's why it still annoys me.
I can be ready. I think that will give enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure the state's going to want to take the deposition. I think they may have a right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time.
That does not take a little bit of time. You just said they need to meet with her. They need to build that rapport. They need to do their tests. They need to make their examinations. The state needs to be able to hire their own experts, take depositions of these same people, make their own conclusions, yada, yada, yada. You can't get that done in 30 days. 30 days. This is going to be a rough awakening for you.
I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance.
No. 2 or 3 months. Do you know how many other attorneys have come in saying the exact same thing? I'm asking just for a little continuance, and then we will be ready to go. In 2 or 3 months, she will been done driven you off, and we'll be right back here again.
The good thing about it is Mr. Padilla has done a lot of the work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We tried, but we have not made it.
Well, you didn't try hard enough. If you watch some of our previous videos, we tallied up. She had 40 hours that she did not use that laptop and digital discovery that she had available to her. Yes, there were some good reasons here and there. However, that was 40 hours. Do you know how much more you could have gone through if you had utilized all the time that you were allotted? 40 hours. You could have gotten through most of that discovery in 40 hours, especially if it really mattered that much to you. It just blows my mind how much she complained and complained and complained and complained, and now she's still complaining and complaining and complaining and complaining. If you had listened to your lawyers ever when they tried to explain these things to you, you would have gotten through it. And that's the other thing. She has been explaining these things for 4 years. It's not like she literally has not seen anything and it all just got plopped on her. No, she has heard about everything in those boxes. Now she is just physically seeing the physical files, not getting the information for the first time, but seeing the actual files. I know they're a mess. I know nothing is organized. Miss Cashman had to take out all of those staples, so it is all free form paper. I'm sure you can't find anything else. And I'm sure it is frustrating, but that's what she wanted. That's what she asked for. And no appellate court is going to say, oh, she can't find anything in the hard copy discovery that she begged for. So now it's our fault for giving her what she wanted. And that's how this is going to continue to happen. If you give another thing to her, it will always be your fault for her abusing it. And honestly, she'd be right. It will be your fault if she abuses the system again if you allow her to do it one more time. It'll never end. It won't. People keep saying, this would be the last one. No, it wouldn't. No, it would not at all. No, it would not at all. They have already given these exact same warnings, these exact same time frames again and again and again, and she always worms her way around it, and she always gets what she wants. This is what she wants. The entire time she keeps saying she wants to go to trial. Kranick was right in his order. She doesn't actually want to go to trial because she doesn't want to be found guilty. And now we're here. And she's going to be found guilty.
My understanding is a lot of the 2-hour interrogation with the Sheriff's Department has been transcribed. They haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, Santa Rosa County, is a little bit different. And based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could, but not without the battered spouse defense, because I don't believe my experts will be ready. And so that's instrumental in our defense.
Ding, ding, ding. That is the final nail in the coffin. You just said, do I think I can be ready for trial in 30 days? Yes, I do. Done. Period. Done. But no, nothing else. You just told me you could be ready for trial in 30 days. Make it work. Who said that? Tim Gunn from Project Runway. Make it work. You can make it work. You just told me you could. So no, I'm not going to give you any of this. He literally just nailed the coffin right then and there. You told me your first nail was you still have like 6 days to try to file this defense. And 2, you said you could be ready in time. That's all Kranick's hearing in my mind.
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several of Ms. Boone's previous attorneys, and in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case, in anticipation of a potential rebuttal of an attempted battered spouse defense.
And there you go. Mr. Cacciatore right out the gate saying, as discussed with many of her past attorneys, because they've all tried to play this game, it's not new. They've had an expert witness on the witness list since day one. Since day one. So I would actually love to have this battle of expert witnesses to see what the state's witness would say, just to completely annihilate anything that whatever expert witness the defense could get. Train, tell me what you think. I'm going to be real with you. I don't think she buys the defense.
The state's position would be that we would impose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
Exactly, and that's reasonable. He's saying he just showed up today. Can we at least give it a week to see if he can do any work at all first before we need all of these extra things he's asking for? So that's fair. do your best for a week. We can come back next week, and then we can complain about what you could and what you couldn't get done. But you just came into my front door begging for things. See, this is why you don't get invited to the cookout, and this is why you don't get to take stuff home.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file the notice of intent to rely on the battered spouse on Monday. We can't wait a week that the time has expired if the judge doesn't continue it today. He wants to have a conference next week, but it's too late for him.
Correct. We're on board. Here we are. Yes, it is too late for that. It's too late for any of this. Too late for any of this. I was so proud of you for deciding to throw your towel in and get in here and get whatever payment you're getting out of this, but it is too late for that. Thank you for finally catching on.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said it, 30 days, not 60, not 90, not 120.
And
I love how petty Kranek is. Exactly. Because they put in the specific provision of 30 days because they said that should be enough time. If they didn't think that'd be enough time to put on a defense, they would have said 60. They would have said 90. They would have said da-da-da-da-da-da-da.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim. I just can't say, hey, we're going to rely on it, and I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she meets the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can file that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brandon needs more time.
Now that's a stronger argument of, I can't just submit this defense. I actually have to have some kind of factual basis to support this. I could submit it with me just saying it, but I'm not an expert, and it wouldn't be a strong or good faith motion or, announcement of the defense, whatever you call it, if I did not have actual factual support to make the claims for this defense. Still a you problem, but I appreciate the honesty.
Thank you. State anything else?
No, you're not.
All right, thank you very much. All right, Mr. Owens, it seems like you've already started to dive into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Ooh, here we go. I can feel it. Okay, this is like the prep up. We are about to find out. Is he going to grant the motion for continuance? I still say no, and especially from this presentation, he's prepping up being like, okay, so you've started to read things. Now let me read you.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions.
I swear this shady cameraman will send me to the grave absolutely every single time. I love it so much. They never miss a beat. Honestly, Real Housewives needs to hire this man. I'm assuming it's a man just because of the shadiness. A woman might have a little more class, but this guy is getting the dirt that we want him to get. Yeah, go over there. Oh, wow. And he said, I gotta wait for this to zoom in on your face, and guilty.
This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order and adjudged portion, that trial specially set for October 7th, 2024, and that it would be not continued for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed and that by your own representation you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020 under Mr. Padilla's representation.
That cameraman is at it again. But what? Look at this face right here. You see, as soon as the judge said that there had been prior expert witnesses, she was like, excuse me? What do you mean? No, there hasn't been. Yes, there has. Remember, you didn't like what they had to say. And yet again, this shady cameraman zooming right in on the writing. I just want to know what's going on in there. I know they're sitting there bored. I know the truth is they are just bored out of their minds. So they said, let me just get some cool, good shots, not realizing I'm about to go and focus my camera on this man's hands and give him no privacy at all.
Ms. Boone, at no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order.
And just a little worldly advice, whenever someone in this kind of context compliments your intelligence, it is not a compliment. It is actually throwing it right back in your face. As you astutely pointed out, meaning you read the same words that I read, we were almost this close to trial years ago. So why would you come back in here with Mr. Padilla's playbook and then try to make the same arguments and ask for a continuance when he already did that? He was ready to go with this exact defense. And now you're mad because I won't let you take more time to rerun the same defense that he ran away from the first time.
Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert.
And there you go. Mr. Hobson comes in clutch again. I think he is the first one to actually say that he spoke with the forensics expert and that the reason they couldn't work together is because they were not, or they did not come up to the same conclusion that Sarah Boone did. So we'll be doing the same thing. And this is what I've been talking about before of if you let her do this, the same exact thing will happen. If they don't say exactly what she wants them to say, then she's going to want to redo it. And then she's going to want to fire them. And then we gave this whole continuance for absolutely nothing. And then you're going to say, well, we don't have an expert and we absolutely need one because we declared it. And side note, I know I'm very repetitive, but these are all repetitive arguments. So I don't know what to do. It is what it is. I'm so late. It's so loopy. I'm so late.
There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023, again by Attorney Hobson on January 1, 2024.
So every single lawyer has tried to go down this route. And if you'll remember, every single lawyer, she said she did not like their plan of action and that there's more than one way to win and more than one way to win for everyone. I still don't know what she meant by that, but you have no ways to win. I've always said that. This is the closest way that they've been like, hey, we might get you not life in prison if you go this route. And she's been combative and doesn't want to do it. But now that she tried to do it on her own, she says, yep, I'll sign up for that defense right over here, me. And it looks like every single attorney tried to hire someone. So whose fault is it? Is it every lawyer's fault who all of them together have probably handled over 1,000 cases in the time that they've been representing Sarah Boone? Are all of them so inept that they just really royally effed over this very simple case, cut and dry case? Or is it Miss Paulson? I think it's Miss Paulson. And I can't remember. Sometimes I'll probably be slipping and say the artist formerly known as Miss Boone Esquire. But Miss Paulson did this to herself.
Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, and Barlow v. State, 221 Southern 3rd 562 at 569, there's a two-part test determining the need of experts. We're not going to be addressing that today, as you've sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here and have the opportunity to review those. In Ramos versus State, 75 Southern 3rd, 1277, at pinpoint 1281, by the Florida 4th DCA in 2011, citing to Lawson v. State, 884 Southern 2nd, 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change of counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation of trial is counterbalanced by the right to the effective administration of justice.
Thank you. Thank you for saying that, because everyone, and herself particularly, specifically, has been latched on to this fair trial, fair administration of the Sixth Amendment, right to counsel, this and that. But this is all about the fair administration of justice at this point. She has abused that right. By allowing her to keep doing this again and again, you are impeding the effective administration of justice. Why? Because then this sets a precedent moving forward of anyone can do anything, because they'll be me, and forget about the victims. And that's what all of this has been. We've said this multiple times. This is all a distraction strategy. But the more that she plays this and the more she says me, the less you think about Jorge Torres. People want her to have a plea deal just to be done with this. No. The reason why there's no plea deal is because the state is probably offering her life with parole, and she doesn't want a life sentence. Trying to uphold an effective administration of justice means punishing the crime, not the person. So even though you're annoying, and it would be so much easier for me to just swat you out of my hair by giving you a quick little plea deal, that is not administering justice. That is discounting George's horrific murder just to not deal with a Karen, Sarah, whatever. So in the interest of upholding effective administration of justice, we must keep this going. Because just getting through the trial saying, oh, I want it to be airtight, I don't want an appeal. Yes, appeals and courts are always worried about the appeals and making sure the case is airtight and they don't want it overturned. That is a high standard. That is a high standard, and the courts balance that when making their decisions. He knows this is not going to get overturned on appeal. They can try their best. Unless she's got money to find the best appellate lawyers out there, this case is going to hold up. So we are going to move forward.
As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankwitz, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and the findings in the court's June 28th order.
Damn, he said she has only herself to blame for this. And this, honestly, this has got me thinking, I think this is a little indication on how Cranick is going to sentence her. He is very professional, very good at holding things in and not coming off any kind of way. But then it's the subtle word choices that really give it away. So he believes, even though he's delivering this in a very calm and neutral tone, she has no one to blame but herself for the situation that she's in. And I bet he believes that in general. Just like with all of her court-appointed lawyers that she's pointing the fingers at anyone else but her, she is saying the exact same thing about her murdering her boyfriend in a malicious act of revenge. And he is going to play all of that in mind when he is deciding how to sentence her. And this is giving me an indication that he believes she needs to hold the responsibility for her own actions and that he is going to do that.
Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida. From 2009 to 2012, you've tried over 100 cases to verdict.
Dang, now this is a true read down. He's like, I'm not even just going to tell you about her, I'm going to tell you about yourself. Okay? She did this to herself with her actions doing X, Y, Z, and a third. You are old enough with your big age and your big experience to know better. So if you were a new lawyer, maybe I could give you a little whatever, but you are very experienced. And I know that if you want to hop on this, you can take this to trial and you can take this all the way through to verdict. And that is what you shall do.
Throughout your career, you've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. And considering all the factors as set forth in terms of the state 311 sub 3rd 185 and 10.189, Florida 2nd DCA 2020, your motion for continuance is denied.
Bon appetit!
And there it is. It's almost like I said that would happen. It's almost like I said he was going to deny it because if he didn't, his word would mean nothing. And I know people are already like, oh, is he going to get it? Is he going to get the continuance? No, I'm going to be upfront and say absolutely not. Why? If Judge Cranick gives him an extension because he is a new lawyer on Sarah Boone's case, then Judge Cranick's word means nothing moving forward. Nothing.
Did I lie? Did I lie? Did I lie?
That was great. That was amazing. Thank you so much, Judge Cranick. You stuck to your guns, you said what you said, and you meant what you said. Love it. Love that. So now we're all on the same page. What he says, he means. So when we try this messy mess moving forward, you know the drill. I don't want to see this doe in the headlights look. You lost, you need to get used to losing, and you need to just be okay with that.
Matter, this trial is still set for October 7th. We will have pre-trial. The 27th. Pre-trial in this matter, or trial case management will still be set for September 26th at 9 a.m.
Judge, a couple of things. Number one, I have a full practice. I've got a docket day this afternoon in Santa Rosa County before Circuit Judge Scott Duncan. I've got 12 clients that are pending. I've got other people covering it, but I do have a full docket.
I don't care about your docket. You came into my home. Literally, that's like inviting yourself to dinner and saying, "Okay, I gotta leave soon though, so can we hurry this up?" No, I'm joking. I get it, but again, I don't care if you got other clients. No one is forcing you to take this one. And I heard he's like the elected public defender, something like that, wherever he's from. Which is good qualifications, yada, yada, yada. But he's acting like he is a public defender, like he was appointed to this, like he has to do this. No, you have to do your other cases because whatever obligations you have for them, you do not have to do this case at all. You are choosing to. And if you are choosing to, you have to deal with the pitfalls that happens. Again, you can't make you a me problem.
If we set some of these hearings involving my motions, could I be allowed to hear by Zoom?
Any objection?
No, Your Honor.
The only request I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion and provide a form order, I'll sign it and you can appear virtually. There's no reason for you to drive all the way down from Santa Rosa County for all these hearings when we can appear virtually. JACS, I imagine, will be appearing virtually for some of these motions with regard to the experts. So as long as you file a notice in advance, sir, I've got no problems with that.
Oh, so he's going to be on Zoom the rest of the time. This might be our only time to see Mr. Owens Esquire in person before trial. So he's done good. You know, I've been poking at him and saying whatever I want, but I mean, he's doing his job and he's doing it for Sarah Boone. So of course I'm going to have some issues with it. But this is probably the best that she could do given the circumstances.
Judge, in that pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to intend to introduce at trial. That has not happened.
It 100% has happened, even though that's not what they agreed to. No, I think he's got it mixed up. He's mixing up the first order where they said, this is before they were going to do the USB digital thing on their own. They said they were going to come in and view the physical evidence and then sit down and review the digital evidence. Today was supposed to be a long-ass day to view everything. That is when that they were going to do that. But then in the August 9th hearing, he changed that and said they're going to give the digital discovery to Billy Lane. Oh, okay, that's it. They were given the digital discovery to Billy Lane. Everyone knows that. Sarah Boone knows that. But when Billy Lane and Sarah, I kept saying Boone, I'm sorry. Billy Lane and Sarah Paulson.
He's escaping! The killer is escaping! Help me!
And Sarah Paulson and Evan Peters, Billy Lane met together, they only got through one item of digital discovery. And that's where all of this is coming from. She is thinking that she didn't get enough time because they were moving their slow time through it all. And she's like, well, they did say originally that they were supposed to view it with me, so I wouldn't have been rushed. They would have had to be there and we would have watched the entire thing. But no, they didn't give us all the time that I wanted, so I only got to look at one item of digital discovery. Wow.
I think today was the deadline for that. I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lane on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intend to introduce. I don't know if they've been redacted. I don't know if they're the originals, but I'm going to need to look at that. And I went to the jail yesterday. I had let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone. to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So
Yeah, I'm not sure why they didn't let him bring that in. Was it maybe because he hadn't made his first appearance and so technically wasn't her lawyer? And I guess they don't let just random people bring in laptops and stuff if they plan to meet with inmates for some reason. But then they wouldn't have let him meet with her for 3 hours if they didn't think that he was some legal professional. I don't know. That is strange.
I would ask for some more time to be able to look, for me to look through the digital evidence as to what I assume is being redacted. I know some of the audio in terms of comments my client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
State.
I'm not certain, is he asking for a continuance again? What is the extra time that he's seeking?
Exactly. That's not clear. What he's asking for is if he can still make objections to the digital evidence even though that date has already passed. But he's not giving any specific dates. He's just, can I get more time? We're at the point where you need to come with very specific requests. Not, I need more time in general and then make us try to figure it out. I need more time. Can I have until X? Okay, we can work with that. But yeah, your biggest issue is that interrogation. That interrogation destroys almost any defense that you could possibly come up with in this case. And yeah, there are probably some things in there that could be suppressed. Sarah Boone should have been focused on that, but no, she was focused going in on one. Oh, she said she only went through one item of discovery. Maybe she spent that whole time looking at the interrogation video and didn't even care about the 9 other things or the 8 other things and decided to waste all of whatever time she had with Billy Lane on that interrogation. I can absolutely see that happening, but I don't know for sure. Yeah, you got to try to get that out somehow. You're not gonna. That's why your motion for additional discovery is asking for the interrogation policies at the time when she sunk her own ship. But you have to try. I mean, you have to. No matter what. You should even claim that she was drugged, that she was this, that she was that. You know, there's so many ways to get out of these sworn statements in the moment. If you're getting that feeling and you're like, oh, they're about to swear me in. Has anyone pressured you into doing this? Yes. Yes, they did. I feel threatened. Brian said he wouldn't let me stay in the house. I couldn't sleep on the couch anymore if I didn't come and talk to you all. Something, you know, it gives you a little something to say, oh, I may not have told the whole truth, or there was a reason why my stories change now. But good luck.
What is it you're asking for? Extra time to do what?
The way I understand the order, I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with station. They never viewed it with my client.
He is splitting hairs with that one for sure. So I want to read that specifically and then see what he's not quite getting right. August 5th, 2024. 4. The state's digital evidence will be reviewed with the state's investigator, defendant, and defendant's investigator no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd, 2024 deadline. The state shall provide defendant a USB drive of the state's digital evidence at this evidence viewing. If this evidence viewing is completed prior to the September 3rd, 2024 deadline, the state shall file a notice indicating the date and location of the evidence viewing with the court and provide a copy to defendant. Which would be all fine and dandy, to use Miss Paulson's words, but there was another hearing on August 9th where things were changed. And I get it, you're new, and that's fine that you don't know this. However, that's not our fault that you didn't read. August 9th, 2024. Number 4. Prison Break investigations by and through investigator Billy Lane shall take possession and custody of USB jump drive which contains the state's digital evidence tendered in open court on August 9th, 2024 and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9th, 2024. They were even the same subpoint on both orders to keep consistent. Yes, I get it. Not a bad argument, not a bad attempt at an argument, but does not apply here.
In its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order.
All right. Take it easy, Mr. Owens, Esquire. The state prosecutors have done everything flipped over backwards to make sure that they give her things and that they set up things. They set up the whole physical viewing just so that the media didn't have to be there, even though she lost and got her ass handed to her by Miss Fugate about letting the media in or out. But the state did that on their own. They decided, we will set up everything to bring her in, to have her have a whole useless physical evidence viewing, and it's useless because now he's got to ask to view it himself. And he is the only one that really needs to view it because he's going to do stuff with it. He can't go to Miss Paulson and say, tell me what I should say. What did you see? Was there blood on the bat or not?
I'm saying I haven't had a chance to view it either. Can we reset that deadline?
On August 9th, Mr. Owens, we had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lane was here. There was a USB provided in open court. And the August 9 order and notice of hearing identifies a change to that August 5 order.
Exactly what we just covered. Great. Just pretend that I inserted what I did back there. Here, I'm not going to change it.
Specifically in paragraph 4, prison break investigations by and through investigator Billy Lane shall take possession and custody of the USB jump drive which contains the state's digital evidence tendered in open court on August 9, 2024 and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigation shall file with the court a notice reflecting that the discovery in the USB jump drive, which contains the state digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail, including the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m. a hearing will be held, courtroom 12A, regarding defendant's review of USB jump drive, which contains the state's digital evidence. The defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. The pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which set this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay. State?
No.
Okay. How much time would you like, sir, in order to review the state's digital evidence that it seeks to admit into evidence and tender any objections?
Well, I've got to go buy a jump drive. I've got to take it down to his office. He's going to give me that evidence. Obviously, I need to review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but...
That is not at all an answer to the question. How much time do you need? Well, I still need to get the discovery and I still need to view it. Yeah, that's what you're asking me for an extension to view it. How long do you need? Well, I need to view. Give me an answer. I'm so over people not coming up with answers. Give me an answer to work with, not this ambiguous, yeah. Because then they want Cranier to be like, okay, how does 7 months sound? Half a year? Okay, you know what? Let's just case dismissed. Got it.
I don't see the necessity of an issue, maybe a week prior to trial, whatever that is, a week prior to that Monday, October the 7th, the week prior.
Steve? I'm going to be amenable to setting a status hearing that week.
Here's what we're going to do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right.
There you go. Another win for Miss Paulson. She gets a continuance on being able to make objections to the digital discovery, which I don't really have an issue with. Yeah, the pretrial hearing sounds exactly where you're supposed to work out those objections anyway. So yeah, go for it.
Anything else, Attorney Owens?
Give me 1 minute.
Sure. State anything else?
Not at this time, Your Honor.
Madam Clerk's going to work dutifully to, it's already done? Excellent. I'll have Ms. Barrios, my judicial assistant, forward these to JC and see if we can coordinate a hearing. State will have till close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. Parties having no other business before the court. Y'all can have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah Boone?
Absolutely.
All right, and it looks like that's it. That is probably the least painful hearing we have had in weeks. So, Mr. Owens showed us what he's got. I like him. I think he's great. I think he's got a good fight to him. He will definitely be interesting, and yeah, probably the best Sarah Boone. Why are you looking back, girl? Hold up. I thought I was done, but I was told that there's a few other things that I needed to view. Apparently, Mr. Owens Esquire did an interview outside of the courthouse after the hearing, and apparently he talked to Court TV on the phone afterwards. So we're going to just check those out, I guess. The video may come out even later now that I'm seeing this, but people are saying stuff and we're just going to look at it. This is not going to be maybe as in-depth of a reaction as the rest of the video, but we'll see what happens.
Excuse me?
Why this case?
Sarah Boone needed a lawyer. I mean, I can't imagine our system. The case is an aberration, okay? This just a gap in the system that hardly ever happens.
Unless someone loses their absolute mind and doesn't know how to behave themselves. Why are they acting like this just came out of nowhere? I can't believe this happened. Yeah, because people don't get 8 lawyers because they're bashing them.
At the federal level, on the state level, everybody charged with a crime is entitled to counsel. Okay, everybody. Never, unless the defendant waives their right and wants to represent themselves, which is rare and foolish. But I understand the judge's ruling. We respect the judge's ruling. But that left Sarah.
He's making it sound like this has never happened before. That doesn't happen unless they waive the right. Oh, did you not read the order that you said that you read with all the case law citations of all of these other defendants who lost and forfeited their right to court-appointed counsel by conduct? So it's not like this is unprecedented, that this has never happened before. I don't know, for some reason y'all just don't like that it happened to her, and so now it's this miscarriage of justice. Whatever.
In a position where she's standing in a courtroom accused of murder without a lawyer. I can't think of any other time that you would need one than in that scenario. So Once that decision was made by the court, Sarah put an ad out. Somehow it got on court TV. I watch a lot of YouTube, true crime. I saw it. I didn't immediately act on it. I waited 3 or 4 weeks thinking that one of the members of the defense bar here in Orlando would pick up the torch.
Sir, what? Okay. There's a lot in that. Accused of a murder that she filmed. Right. So it's not just you're accused of a murder, she filmed it. So there's a little bit of a difference. I know legally there isn't, quote unquote. However, there's a reason people didn't jump for joy to try to get this case. Also, they've seen her actions. You should have seen her actions too before you signed up with her. But yikes. And like I said, you could not interrogate the information out of me that I decided to represent Sarah Boone because of that circus help wanted ass poster that she wrote and posted online. And then say, because I watch a lot of YouTube, just say you saw it in the news, right? It's all posted in the news. Just make it look like you saw reputable sources, not I was gossiping online on YouTube while I couldn't sleep and I said, hey, maybe I could ruin my career. I don't know. If you've had 35 years of experience, I don't know why you think you need this kind of publicity, but maybe it'll work out. I mean, he is a great attorney, it looks like. So even if someone just sees his actions here, that might be enough to get him more business, but we shall see. I waited 3 to 4 weeks, and every single three, you know what? Go back and tell Kranik. Go back and tell Kranik I waited 3 to 4 weeks to jump on, and that's why I need a continuance. If you jumped on when you first thought about it, you could get all of the experts you wanted. You could get all this opinions, and you could have announced this battered spouse defense way earlier. But whatever.
3 or 4 weeks went by, it did not happen. I had another case down here in Hillsborough County in Tampa that I had to come down for. So I wrote her a letter about a week before that. And
Not you writing letters now. And that's how it all begins, right? They both wrote each other some love letters, and then it's going to end. Yeah, it's going to end.
she had a third party, a girl from Minnesota, that reached out to me, I think first just to see if I was legitimate. They said to see if I think catfishing is what they thought I was doing, somehow, some fraud. I think once the third party realized that I was genuine, then Sarah called me. And we talked on the phone a couple of times. And I said, hey, I'm coming down that Wednesday for that court case in Tampa. Why don't I just come down Monday, which I did. I got done with court, I think, Monday at noon. I drove down 6 hours, spent the night, got up the next morning. I think that was on the 20th. And I spent about 4 hours with Sarah Boone at the Orange County Jail.
Good grief. 4 hours. Yikes. And a 6-hour drive. These are a lot of intentional decisions. Just like Miss Paulson, these are a lot of intentional decisions. So I don't want to hear any complaining with the outcome. You know what you're walking into. You made multiple intentional decisions to be a part of this. So if things hit the fan, or if she's mean, or if y'all have an adversarial relationship, that is all on you.
During that period of time, I was in talks with the prosecutor, let him know what I was doing. He wanted me to file a notice of appearance. I wasn't ready to make that commitment yet. Didn't do that, but I got Sarah to sign a document essentially saying, you know, you can speak to the prosecutor on my behalf. There was attempts to try to resolve it. If we would have come to terms, I would have filed the notice of appearance. We would have set it for court, set it for hearing, and the case would have been resolved. So we did make attempts like everybody does in every case. Any prosecutor, any criminal defense lawyer, public defender, you have plea negotiations.
There it is. And there it is. Because we wondered what happened from the hearing with the plea negotiations. And the state was like, I guess we're going to go see, because she said she wants to talk about plea negotiations. So it must have been talking with this guy about potential pleas, and they couldn't settle it, because my belief, I still think the state is offering life. Why would they budge?
It's not like they are in any threat of actually losing this case. Why would they budge? So they're going to go through with it. And of course, she probably, maybe they did offer her a reasonable plea. People have said that they've offered her 15, 10-year pleas. I don't see any proof of that. I feel like that's just a rumor because that is a very low plea for a second degree depraved heart murder, I think. So we'll see. She probably may have proposed that kind of plea. Can I get 15 years? Can I get 10 years? Can I get whatever? Because they did not offer her a plea of manslaughter or any lesser included. They are going for second degree depraved heart murder. And she will have to plead guilty to that to get any kind of plea deal. So you can't plead guilty to a lesser included and then try to get that sentencing. You will need to plead guilty to second degree depraved heart murder, and then they can negotiate the sentence from there. I don't think she wants to do that.
It's just part of it. So there were attempts to settle it. I was kind of like a mediator. I was kind of like a go-between, because once she became pro se, it's very difficult for the prosecutor to then communicate with the defendant. Actually, the rules say you got to do it on the record. And you can imagine not having somebody to negotiate for you, and she's trying to negotiate with the prosecutor, trying to send her to prison for the rest of her life. So.
Oh, yep. So that's subtle, but he just gave it away. He just gave away that they offered life, that the prosecution is trying to send her away for life, and that it's so sad because she doesn't have anyone on her side to advocate for her and to say, please, please don't send me to jail for the rest of my life, even though I ended someone else's life and laughed at him. Be nice to me. Oh, I know. I've just lost any kind of sympathy. The more you learn about it, the more annoyed I'm at with it, the longer that it's taken, the more resources people have used. There's easily been over $100,000 worth of tax dollars that's gone into this, easily, with that many other, because it's not just paying the lawyers, right? It's paying the judge, it's paying the bailiffs, it's paying every single person who has ever laid hands on this case is not doing it for free. And all of it have to be scheduled to include her and to do all X, Y, Z and a third, da, 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 da. And so we've reached a point where the curtain is about to drop and there's no more plea deals. There's no more niceties. I'm so glad that she finally has a lawyer, because now the gloves come off. They don't have to be nice to her. They don't have to like throw soft punches. They can go for it because now she has representatives, uh, because now she has legal representation that can take it. They can rip her to shreds with the evidence that they have. Because when she's pro se, they have to pull their punches because it looks like you're beating down on her. And if she's, saying that she's already been beaten down by all of this and all of that, she can elicit sympathy. But with another lawyer, you're just going facts v facts. So I'm glad you're here. Hope you can last until the end. There is a chance that you might pull out. I can see that happening too.
Somebody had to do it. I was doing it. But after those, so I met with her that day. I went over to Tampa, handled my case. I think I was done at 2:30. I came back. Well, Billy Lane, the investigator that's assisting Sarah Boone, pro se, he had scheduled an appointment to meet with Sarah that night. So I went back over to the jail. They let me meet with them. So the three of us met. This was, I think, the 21st. Like it's set from 7 to 8:30. We met for about an hour and a half. And at that point, we couldn't reach an agreement. And then I wasn't ready to represent her at that point. I immediately told the prosecutor that there was an impasse, there was no agreement, that I was not going to be representing her. I got in the car and drove back home, got home about 4. I had court the next morning at 8.
Okay, there's a lot embedded into that. So you met with her and Mr. Billy Lane late one night, and you probably were bringing her the prosecution's offers, and she said they could not come to an agreement and that you were not going to represent her. So that could not have been a great meeting. if one, you didn't want to represent her by the end of the meeting, and two, y'all didn't agree on nothing.
8:30, I was done with the case. I did the best I could. I want to say 2 nights later, my wife and I were home, and Sarah called, and we talked again. Of course, I was still thinking about it, what to do, and but I told Sarah I was not committed to doing it. That was on like the 23rd. Well, then that third party called a day or two later, and really nice lady that I really respect. We've developed a relationship, and she asked me if I would go one more time. So I flew back down. We met again a couple of times. I can't remember the dates now, 25th and the 26th. But both meetings went well. And you got to understand, Sarah's been through 8 lawyers, so there's some trust issues. And
trust issues, that is translation for everything did not go fine, but he survived, so I guess that counts.
On both sides, you know, I'm concerned, is she going to try to fire me, or we're going to have problems the same way, as you can imagine. But you know, I like her, she likes me, we communicate well. I think we're both on the same page, and you know, I spoke to my family, my wife, my daughter Sarah about it. Sarah's thinking about law school, so.
Whoa, 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 whoa. And there it is. You have a daughter named Sarah. You have a daughter named Sarah? Of course you do. And that's why you feel this connection, and you feel like you need to protect her, because you see your daughter in that. She wants to go to law school. That's crazy. That's crazy. Of course your daughter's name is Sarah. Now, at least all of this makes sense. So he's going to try to save her. He's going to treat her as a daughter, and it's going to be as messy as it possibly can be.
I got their blessing. I have, you know, some colleagues that I practice law with, a law group there in Milton. And obviously it's going to take some staff to pull something like this off, especially knowing that the judge, I was in hopes he was going to continue it and give me 2 or 3 months. He did not. So we've got about 30 days, so I'm going to have some help from the staff, but I'm trying to assemble a team right now. I've got a couple of friends that are lawyers that have.
Okay, but you just said you expected them to extend it. Did you really expect to get the continuance? Sir.
Have indicated they're going to help me, and what are friends for?
Are you doing it pro bono?
I've been retained.
You've been retained? Retained by whomst? Retained by how?
I'm not doing it pro bono.
Who's paying for
it? Sarah owes me.
Sarah owes you? Wait, what?
Sarah owes me.
Can you speak a little more to your...
He said it twice. Sarah owes me. Sarah owes me. And I'm putting that on record so she knows. How on earth did she convince you to come here? I mean, I'm guessing it has to be some daughter connection, some, you know, I pulled your heartstrings and tell you I've just been battered. I've just tried so hard in this, tried so hard that. He even admitted he hasn't gone through all the discovery. So what's going to happen when he goes through it and realizes she's full of it? And now you're in too deep and you've put your face on national television. Wow. I'm sorry. No, I zoomed too. I went back too quick. She owes me. Sarah owes me. He says, Sarah owes me. That's going to be in the title or the thumbnail somewhere. Sarah owes me. Wow.
Well, you know, I'm not an expert, but I don't know if we're going to be able to do that because we're time crunched now. As you know, I think you all understand the rule now. We've only got till the 9th, which was today, the 3rd. We've got 6 days. So I'm going to try to pay for Dr. Julie Harper to fly down here later this week. she's actually from my area. The two experts that I had asked for, well, there's a third one, but two of them are from my area. Dr. Harper's from Okaloosa County and Dr. Birkeland's from Escambia County, but I've been in communication with Dr. Harper. I think I'm going to get her to fly down here later this week to meet with Sarah several times. Hopefully, at the end of those meetings, like I said, she's already met with her, but it was 2 years ago. She met with her 5 or 6 times. Hopefully, she's going to agree with me that she does suffer from battered spouse syndrome.
And what if she doesn't? And what if she doesn't agree with you? Like most professionals haven't and shouldn't and won't. So what if she doesn't agree?
So then if she's able to give me that opinion by the end of this week, my intent is to file the notice with the court and the clerk of our intent to rely on that defense, and then we go from there. That's really all I can say. It's up to Dr. Harper, not me.
That's really all I can say. You have said everything. I don't know why you were given this interview. I don't know why you were given so much information, but you are telling it all. Telling it all.
So you've got 6 days to do that. Now, barring a Matlock miracle and that doesn't occur, what is your other, I guess, plan of action?
Well, you know, Sarah's been sitting in jail for a while. She's looking for her day in court, and we all want justice to be served. You know, I'm a criminal defense lawyer. I've been doing it a long time. The state has the burden of proof. They have to prove their case. I know there's some strong evidence in the case, but there are some explanations.
Really? There's some explanations for why she filmed him? That's the most important one you got to prove. Why did you film him, and why did you walk away? If you can't answer that, you got no explanations.
I'd rather not get into my other potential defenses, but we do have some defenses. They've got to convince the jury beyond a reasonable doubt. That's all I really want to say. You know, just like any other lawyer facing a trial on a criminal case, the state has the burden. We're going to test the state's evidence, and then we've got potentially a case to put on. But we'll see. We'll see what happens into this week. It'll be interesting to see if we can.
Potentially a case to put on. That's your pivot point. You can't put on a defense. You don't have to put on a defense. You just said they have to prove beyond a reasonable doubt. If you can sow enough doubt into every one of their witnesses, then you don't need to put on your own defense. So it's not going to be impossible for you to get something done in time.
And utilize, because I do believe she meets the criteria just from everything that I have viewed in terms of Mr. Torres' prior arrest. I did want to say something else, but I want to say something, but I'll wait for you if you got. We got to move downstairs. Okay.
Or I mean, we can just wrap it.
The prior arrests. So you really, really want to dig into these prior arrests, which means they're going to dig into her prior arrests as well. I don't know if he realizes that. I don't know if he has read those affidavits from the police officers and the arresting officers. He says he's looked into it. So I guess he's only looking into her story of things. Have you looked into the 2018 one? Because it's just a messy door to open, right? If you start saying, look at his past, you have to look at her past. Why? Because she's the one on trial, not him. He's dead because of her.
Let's wrap it up.
I did want to say this. The Torres brothers are violent.
What?
Towards women. I'll say that again. The Torres brothers.
What?
George and Farrell Torres
No.
are violent
No.
towards their women. Farrell Torres is George's brother. Are y'all aware of this?
Fuck off. I'm so over this. Oh my gosh. I am so over this. Wow. I'm enraged. So she's just going to put his whole family on trial. That is her plan out of this. She's going to put the family on trial. So if you don't know, one of George's brothers, I think within the past 4 or 5 months ago, killed his partner by stabbing her. And it was a horrific scene. And that's unjustifiable. and he's going to get exactly what he deserves. So that is what it is. However, that has nothing to do with Jorge Torres nor his death. This is mind blowing. So you're going to say, look at two violent individuals in a family, even though 4 years later, one Torres brother killed someone, still unforgivable. That's his own life. That's 4 years after he was murdered. So now you are saying, are you going to tell the jury, hey, look, I know my client murdered in cold blood Jorge Torres, but his brother was evil, which means that he would have been just as evil as his brother. So it is okay for her to have killed him because 4 years from now, his brother is going to kill someone, which means it's okay for me to do. Fuck off. I'm sorry. That pisses me off to no end. It is just more disrespect to the family again and again and again. And I'm not trying to protect the other brother. Like whatever's happened to him is going to happen to him and he deserves it. However, his life, his mistakes, his atrocities should not be brought in to George's murder investigation. That is just callous and just so gross to me. Work on your own defense, not trying to point fingers at someone else. But that's all she does. She can point fingers at everyone else's faults but her own. And I bet she had something to do with this and putting him up to saying this. Because that's the narrative she's been playing the entire time. She has nonstop tried to paint his family as vicious murderers, and they have one in their family now, and now she's going to paint all of them that way. Wow. Wow. Sir, and I liked you. You better backtrack real quick.
In May in Seminole County for killing his girlfriend, the mother of his children. He stabbed her to death. I've got the file right here.
You got the file?
He called 911. Eventually, the 911 operator got around to, where is the weapon? Where is the knife? It was still in her head. I don't know. Sarah's told me about the family, the dysfunction.
Sarah has told you about the family. Did she tell you she assaulted them? Oof, of course. Sarah's told me about the family, so they're all violent murderers, killers, yada, yada, yada. I can't. And you have the audacity to say, well, first of all, you're trying to make direct parallels. It seemed like he killed her and then he called the police on himself. Horrible, not justifiable, but they're different. And a knife in the head, horrible, unconscionable. But it's being zipped in a suitcase. It takes longer to die than it does being stabbed in the face. I can't believe I just said that, but I can't believe he just said that either. Like, if you're trying to compare the two, they're both heinous, unforgivable. So your client does not get to fall in the background and try to push someone else's forward and say, oh, look how bad this is. And don't look at the fact that I locked someone in a suitcase and now I'm trying to blame him and his family for me murdering him. It's their fault, is what they're saying, for her murdering Jorge Torres. Wow. Completely unnecessary.
I seriously doubt that's going to be admissible in my trial.
No, it's not. And you knew that. You know that that is not admissible in this court case whatsoever. You're just putting that in the media because you want to blame and say the Torres brothers. You realize those two aren't the only brothers in that family. There are multiple other brothers as well. And you said the Torres brothers, all of them, dangerous to women. Fuck off. I'm sorry I'm cursing that this much. Like I'm heated. I am upset. I cannot believe this is so unnecessary. And you just had a solid hearing. You had a solid hearing. And I get it. You need to put your narrative out there, but it's a disgusting narrative. I don't have to like it. I don't have to respect it. Your client is guilty as fuck. And if you're going to go ahead and paint his family and everyone in it as guilty, vicious murderers, then I can do that with your client as well. Ridiculous. That said, all of my well wishes, hearts, feelings, emotions, prayers, thoughts, and prayers, but that just feels superficial to say that, but goes out to her family and anyone affected by her passing and her death.
that is unforgivable, that is unconscionable, and he will and should be held responsible for it. However, that has nothing to do with George Torres's murder.
There's two sides to every story. And Sarah's got a story to tell.
I bet she does.
I think she's been
what?
mistreated.
Oh,
to some degree.
oh, she's been mistreated.
It's difficult to represent yourself. I wish you could just imagine.
Difficult to represent
you had a
yourself.
daughter.
So you're saying she's been mistreated by having to represent herself, regardless of what she's done to get her there. It still blows my mind. I do not know why people are backflipping for her every 5 seconds. She is not this little victim that she's portraying herself as. She is a violent murderer, violent to multiple people, all genders, all races, all anyone. No one is safe from her. And yet you want me to believe he caused it. There's discussions to be had. There's nuance. He was very abusive as well in the relationship. It is different based off of primary aggressor, secondary reactive violence. It gets so jumbled. It gets so messy, but no one deserves to be locked in a suitcase and laughed at as they're begging, pleading for you to open up. But now you want us to open up to you and to have all this compassion, all this sympathy, all this empathy, all this pity for you, for what you've done to get yourself in these situations. We should pity you for you murdering George. We should pity you for you berating 8 different attorneys. Technically 4, but 8 in total attorneys that were appointed to your case. They were. It was 8 of them. I know you don't want to. Regardless, 4 of them left because of your actions alone, and you're still playing victim. She's been mistreated because she berated all of her attorneys, because she called Bankowitz 5 to 10 times a day, because she emailed and lettered and called and berated and did anything negative she could to get people to do things that she wants them to do. She's going to do the exact same thing to you, and I have no sympathy for what comes your way, because how dare you say that? Oh my gosh.
That was in her situation where she's representing herself, or maybe a sister. Just for 10 minutes, just think about her situation. You know, she's backed into a corner, and she's the type, like most of us are, they're going to come out swinging.
Yeah, you're right. You're damn right. She is going to come out swinging regardless. If she perceives a slight, whether there's any danger or not, she is coming out swinging. That's why you'll notice almost all of the root of all of her times calling the police, almost the root of all of it, her stories start with him calling her names. Start with him calling her a whore, or him saying this, or him saying that. Because in my mind, that is what triggers the violence. She considers that. She says, oh, you think you're going to say that to me? And then she attacks, and then he responds with equal and or more violence. And then she's shocked. And now she's like, well, I was just, doing whatever because you called me X. Now you're actually hurting me. I'm afraid for my life. You're a monster. That has been the proven track record for this more often than not. I don't know how much I'm going to leave in this because I'm very heated right now. This is so unnecessary.
Some of it is probably appropriate. Some of it has been inappropriate. But
none of this is appropriate.
All she knew to do was to fight, and she's been fighting. She didn't have to fight anymore. I'm going to do the fighting for her. So.
And
she feels good about it. I feel good.
There you go. There you go. That's exactly what she's wanted. That's exactly what she's gotten. And that's exactly what she's done her entire life, is to get someone to fight for her. That is why she goes above and beyond everyone to insult them, to berate them, to control, manipulate, abuse them. If you're not going to do what I want you to do, I'm calling the property manager. I'm calling the police. I'm calling my ex-husband. I'm calling the judge. I'm writing a letter to the governor. I'm talking to the captain, the corporal, the lawyer here, the lawyer there. She does everything to get someone else to fight her own battles, even though she is the one who normally starts fighting. She has no issues throwing punches, claws, vitriolic words, anything. As soon as they turn back and look at her, I need someone to come save me. I didn't do this. I was just doing that. And da 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 da. Well, maybe it's because it's late. Maybe it's because this video has taken longer than I wanted to. Yeah. Mr. Owens, you are on my list now. You're on my list now. I really liked you. Lost a whole bunch of respect for you after this.
About it. We want justice to be served. We feel like if we get a fair jury, that we got a good chance. That's all I'm saying.
Thank you. And I agree with you there. I agree. If you get a fair jury, justice will be served. And when she gets a life sentence, justice will be served. There was also this audio phone call he had with Court TV. Honestly, I'm upset to the point where I don't even want to listen to his voice anymore. And I might just cover that in another video. I hear this Court TV, they had a body cam video that I haven't seen. A body cam video from September 5th, 2019, I believe, if I'm reading that right. Just a few months before George was killed. And this is another instance. And from the brief little things that I've seen, she doesn't have a story put together there either. And so I want to dedicate a whole video to that. And I might just tack on his phone interview somewhere in there. But yeah, I think I'm done for this one. I think he got me. I think he got me at the end there. All right. So yeah. That was a roller coaster right there. I think I am done for today, though. Yeah, that ending. So this is spicy. This is interesting. We got a lot of new insight and information. We know they're going with the battered spouse defense. We know they don't have time to get it done. And we know that their backup plan is to smear George's family and to call them all murderers and to just call herself the victim. And he said that she told me about his family this and da 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 da. And every single chance she gets to every single police. That's another thing. I want to track that. I think she has almost called out his family in some negative way in every single interaction with the police. Every single one. But that's neither here nor there. Thank you all for being patient with me. Again, I know this got out later than I'd like it to, but I hope you enjoyed. Oh, also just side note, wow, we hit 5,000 subscribers. It has been 2 months and we hit 5,000 subscribers. That is more than I ever thought I'd ever get on any kind of YouTube channel that I ever would have maybe thought to start. So it's pretty mind-blowing. I'm shocked every day. You all are really nice in the comments. And I like the community that we're forming. You all are really nice in the live chats. I've seen some other channels have really toxic comment sections. Not really here. So please, let's keep that up. Let's not let Sarah Paulson infect us with her energy and negative yada 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 yada. So yes, thank you so much for all the support. Thank you for following me on this journey, and I hope that, you know, we can stay on this ride a little while longer and see where this journey takes us. So remember to comment, like, subscribe, dislike if you're feeling it. Until next time.